Good day, ladies and gentlemen. Joy Stephen from the Polinsys Studios, and here is another Student Herald case law video. Olowolaiyemo versus Canada. Case laws are not meant for people interested to apply for permanent residence to Canada, but may be used by those who feel the system may not be fair, or to gain an understanding of the recourse available in Canada for a negative decision. Content for this video is sourced from information distributed by Thomson Reuters. Judgment for this case is attached in my blog reportersreport.com as a PDF document. This is an immigration case law and also includes topics like refugee status, procedure, admissibility of new evidence. Refugee claimant was citizen of Nigeria who submitted claim for refugee protection based on his sexual orientation. On February 28, 2014, Refugee Protection Division (RPD) refused his claim. Claimant appeared to Refugee Appeal Division (RAD) and submitted as new evidence statutory declaration from man dated May 7, 2014, corroborating that he was dating claimant in 2012, and sworn affidavit dated April 28, 2014 of sister of claimant's male partner in Nigeria. RAD found that affidavit did not meet statutory requirement of S. 110(4) of the Immigration and Refugee Protection Act of Canada, since it could reasonably have been obtained prior to rejection of refugee claim and no explanation as to why it was not available. RAD concluded that while it is satisfied statutory requirements, statutory declaration did not meet factors set out in their earlier case regarding acceptability of new evidence, as it failed to provide sufficient detail on relationship with claimant and was not material. RAD refused to admit additional evidence under S. 1104 and dismissed appeal. Claimant applied for judicial review. Application allowed. RAD erred by unreasonably interpreting requirements of S. 1104 and refusing to admit new evidence produced by claimant on that basis. Test in S. 1104 is disjunctive, not conjunctive, and accordingly, new evidence may be accepted by RAD either if it arose after rejection of claim, or if it was not reasonably available or person could not have been expected to have presented it at time of rejection. If sufficient, it sufficed that new evidence met one of these elements of RAD to consider accepting it. Conversely, in order for RAD to conclude that new piece of evidence does not meet statutory requirements of S. 1104, it must consider whether evidence fails to meet both conditions laid out in provision. RAD's analysis ignored first part of test under S. 1104. Unreasonable for RAD to merely import and automatically transplant criteria from earlier case in its determination under S. 1104. Factors in case which include consideration of newness, credibility, relevance, and materiality of evidence not necessarily applicable to admissibility in new evidence in context of RAD appeal. RAD appeal is appeal and reconsideration of RPD's decisions, whereas PRRA officers' role does not include revisiting RPD's factual findings. Role of RAD to appeal materially differs from that of PRRA officer. Here, RAD referred extensively to factors and relied more specifically to materiality to conclude that statutory declaration did not constitute new evidence pursuant to S. 1104. RAD did not consider whether or how those factors could be adapted in context of new evidence submitted on appeal. Interesting case, Olowolaiyemo versus Canada, dated July the 22nd of 2015 from the Federal Court. Thank you.